It's working. One more minute.
Yeah, I
There
think
we
you're good
go.
to go.
Yeah, we're
I see
good.
that it's streaming.
Okay. Well, I'll officially call the meeting to order. Welcome, everybody. It's good to see you all again, and welcome to our guests who are joining us again to help us get through this. So, before we get started, I'll remind everybody of the state Government Ethics Act and the duty to avoid conflicts of interest. So, if any committee member has any known conflict or an appearance of conflict, please make that known and refrain from any participation. I don't think we've had any conflict issues heretofore, so we should be all right. Um, all right. So, how we want to get started? I reviewed the amended rule. I even want to start with comments. Nicole, you want to fill us in on that, and then we can get cranked up on comments. Is that okay?
Brian's actually going to provide the summary this time.
Yeah, I'll do that. And Nicole, can you make me a co-host, Nicole, so I can share my screen? I figure just to be good to have some visual assistance here for where we are at. Um, so I want to let's see. Do you know how to make me a co-host?
Yes.
Okay, there we go. All right. So uh, this is where we were before. We were talking about this rule at our last meeting. Of course, the backdrop. I'm skipping over the backdrop, but we all know we're talking about how do we deal with this issue of public defenders' offices that are typically treated as a single law firm, even in a particular district. They might have multiple offices in a particular district because there's multiple counties in a district. But for the purpose of the rules of professional conduct, public defender offices are considered essentially one law firm. And so, or at least a particular district's public defender office is considered one law firm. And so we run into that issue of, you have that attorney who has represented a defendant in 2015, and now there's a new person appointed to be represented by the public defender's office, and it turns out that the let's say the victim or the alleged victim of the criminal action is the not just your former client, but one of the key folks that's supposed to be testifying, and so it creates these different conflict scenarios. So we are looking at this situation. We looked at the rules. We looked at the rules of professional conduct, and I think in terms of drafting an opinion, the opinion didn't really feel like it was the right place to address this issue. We had a draft opinion that I think everybody just had some heartburn about because it was trying to kind of carve out an exception for a variety of reasons. And so we looked at the rule itself because the rule really that comes into play is Rule 1.10, the imputation of conflict rule. So we looked at this language. I'm going to zoom in on it here for all of us to see. We focused on this language here. This was the first proposed amendment to the Rules of Professional Conduct that essentially would say the disqualification in paragraphs A and B of Rule 110, and that's the basically the imputation of conflict rules, that those, when applied to members of the Public Defender's Office or the Attorney General's Office, the North Carolina Department of Justice, can be resolved by following the screening and notice requirements that we have elsewhere in the rule. The conversation last time was really focused on this question of how does this work out practically. I'm going to clear out the North Carolina Department of Justice because I think we've had a longstanding ethics opinion that recognized the Department of Justice at times being statutorily required to provide representation to different state agencies. State agencies can quarrel with each other. They may have disputes with each other, and so we have an opinion from the early '90s, or excuse me, I think it's actually 1989, where the State Bar said that the direct technical application of the rules of professional conduct with regards to conflicts in the Department of Justice really isn't practical. And so basically there can be some screening sort of efforts made to allow the Department of Justice to represent one agency against the other, even though they are one Department of Justice, one quote unquote law firm, so to speak. Applying this to public defender's office is where we started getting mixed up. And so one thing that was pointed out rather quickly was, doesn't this seem to say that a public defender's office can represent two co-defendants, two current clients, and recognize that the rule as proposed would have said that, and I don't think that was the intention. Everybody had some heartburn about that, and we also talked about that each one of these scenarios needs to be evaluated by the chief public defender in that district, because if we're entertaining the thought of, let's say, we're dealing with that scenario that I first articulated, a former client of the public defender's office years later is now the state's primary witness, and so that would require the public defender to essentially cross-examine their former client, perhaps even on the information relating to that prior representation, particularly the public information, criminal conviction, things of that nature. And so the thing that we were trying to kind of resolve is that each one of these situations is really going to be so specifically influenced by the circumstances of that office. How long ago was the representation? Is the lawyer who was primarily responsible for that former client's case still with the office? What sort of access to that information exists for the entire office? Things of that nature. And I think the group reached a consensus that really the Department of Justice, the chief public defender in that district really needed to be involved in making the call on whether or not the public defender's office could or could not successfully screen somebody or any sort of prior information off from the current representation. So that's where we were instructed, staff was instructed to go back and rewrite the proposed rule just to see if we could actually fit these different considerations in. And that's what I sent out after the last meeting. And here it is. This is the language that we came up with. So again, I'm going to zoom in so we can see it all, or I'll be on the same page. And basically we separated out the rule. We were talking about the Department of Justice is just a little bit different. And that's the one where we recognize the current client conflict issue has been kind of, I guess, permitted for the Department of Justice, because as we just talked about, agencies might have disputes with each other, things of that nature. And so that remains intact as far as the principle or the conclusion that was drawn in that ethics opinion. We've now codified that. But then getting into subparagraph G, that is where that's where we get into the question of how does this apply to public defender's offices. And this time we limit the conflict, the imputed conflict question that we're tackling here to just former client conflicts. So this would basically take off the table this question of could a single public defender's office represent two co-defendants that might need to throw each other under the bus, whatever it might be. That's not at issue. That's not allowed. That would still be prohibited under this rule. Rule 1.9, though, when we're talking about former client conflicts, that's where this whole scenario comes into play in new Rule 1.10 subparagraph G, that essentially a public defender's office can screen off somebody who's previously represented a former client of the public defender's office that now needs to be involved, in whatever aspect of the case, the current case that creates that conflict. And then scrolling down to the comments, that's where we also we had a comment first, and this was from the original draft proposal. New comment 12 basically articulates why these exceptions are recognized or why we are recognizing these exceptions. That essentially, public defender's office is providing constitutionally guaranteed representation. And that's, why we're looking at this and why it's limited to the public defender's office and the Department of Justice. Department of Justice is providing statutorily required, statutorily guaranteed representation. And so in light of those legal obligations, then we recognize this kind of slightly different approach to the imputation of conflict rule. It would not be available to private law firms or anything like that. We're dealing with something just very different here. And that's what comment 12 really gets into, kind of providing the basis. But then comment 13 is the new comment that was provided in the kind of the revised amendment that talks about how the chief public defender of any public defender office is the one that's going to be tasked with making reasonable efforts to ensure all of those assistant public defenders are complying with the rules of professional conduct. And that's why the chief public defender in a particular office needs to be the one that makes the determination as to whether that office can remain involved in the current representation, recognizing that there's a kind of an imputed former client conflict. So it puts it into the hands of the chief public defender to kind of make that call given their supervisory requirements. So that's where we are at right now. Again, we are, I think as staff, I guess I want to be clear that we are trying to figure out just how can we resolve this issue. We are seeing public defenders offices, of course, more public defender offices in North Carolina. We're seeing less folks on the court appointed list, and we are reaching that crisis, and we've already reached the crisis where folks need to be represented, and it's just becoming very, very difficult to get that representation. And this would resolve one of those issues that we've seen with regards to the former client conflict issue that continues to rear its head. So I guess that's the overview. Be happy to hear anybody's thoughts on the revised amendment. Is this something that, now that we see it on paper, what's our reaction? Do we like it? Do we think it makes sense? And I guess I will also add just that we would not be the first jurisdiction to recognize the unique representation provided by public defender offices in this manner. The imputation of conflict rule and Nicole, correct me if I'm wrong, but I believe it was Wisconsin and South Carolina, both recognize that the imputed conflict rules, when applied to public defenders offices, just can and maybe need to be viewed a little differently. And they have this ability to screen for former client information and all that kind of stuff. So we're not, this isn't a fresh idea, brand new off the top of me and Nicole's head, where we're looking at some other jurisdictions. And I think it is comforting to know that we're not going off on our own and coming up with a brand new rule in some regards, but that's where we are right now. And we'll be happy to talk over any other aspects.
Great. Thank you, Brian. Who wants to lead us off? Anybody got any comments?
Well, since I'm always the loudest in the room, I want to say that I love it. Excellent job, staff. I definitely think that, it's important to empower the individuals who are on the ground to do what they need to do. And if a public defender thinks that, hey, we have enough resources that we don't need to utilize it, we can, but it gives opportunity for those who do need it too. So we're meeting the needs of all 100 counties, I think, with this. So I love it. Thank you.
Thank you, Judge. Anybody else?
I agree. I think it gives the public defenders the flexibility, but still protects them. So I think I was concerned about maybe a judge saying, the bar says you can take this case, you will take this case. And I felt like we needed to give them a buffer where it remains in their discretion, where, okay, this lawyer's been gone 20 years, it's not really a problem, versus, oh yes, this man came to our office every day for a year and everybody knows him by name. Those are very different situations. And I like that we're leaving it in the chief's hands. I think I had read the July materials, so I missed the addition of a G. But I just want to ask a question. We're clarifying the G is specifically talking about Rule 1.9. So that's the co-defendant's issue. Is that correct? So it's one subsection for other conflicts, and then we've just added to clarify specifically for like a co-defendant situation.
Right. Public defenders and past clients.
Past clients. Okay. All right. I was new on that. I had missed the second attachment, but I just wanted to make sure I was reading that correctly. Thank you.
Thanks, Tara. How
Tom?
about our public defender and appellate defender guests? I'm anxious to hear your comments.
I would probably I want to hear from, I think Mr. Ward is here and Ms. Baker Harrell are both here. As the president of the association, I only have a one county district. I think the biggest thing is making sure that the chief public defender is the one in charge of it. But as far as the other language, I would leave any comments up to those two who actually run multi-county districts.
I can go first, if that's okay with you, Woodring. I like this rule. It is so needed. My district is very rural. We do not have the attorneys moving into the area that we did even 10 years ago. Tara's been practicing here for a long time, and she's one of the newest members of the bar here. So we are facing a crisis here, particularly in counties like Bladen and Columbus, where in Bladen, there's some list, I don't have any attorneys. So being charged with indigent defense in this district and making sure that people have zealous advocates that will stick up for them and will do a good job. I really appreciate the fact that this rule gives the chiefs a lot of discretion and leeway to use the rule when we need it, but we don't have to use the rule if we feel like it would not be in the client's best interest, or it would be iffy at best, or if it would cause any further issues. So I really appreciate the rule. I appreciate the subcommittee's work to get it done, because we are in crisis in rural parts of the state.
I'm going to chime in now. I appreciate the rule. It serves the need. While I only have two counties, we are in desperate need of attorneys on our list. Right now, I have only one person on a misdemeanor list, and I'm desperately searching for attorneys for that misdemeanor list, because I have 6 clients currently waiting for attorneys right now. This rule would allow or give me some leeway to look at it, to look at our cases a little differently, to see if it's a possibility of perhaps offering representation for those clients. Still may not be able to, but it allows for the possibility. And that's very important when you have to explain to a client who's calling in every week and saying, I'm still trying to find an attorney for your case. Please bear with us. So I do appreciate this rule, and I think it would help. It would help the districts who are in need of attorneys and may not have them, and we're leaving it up to the chief to try to look at the case and examine it closely to decide if there's some benefit or if there is a possibility of keeping the case in-house versus farming it out to someone.
Thank y'all for those comments. Who's next? Anybody else?
May I just ask one more question? I was not able to attend the July meeting in Cherokee. Anybody who's there, could y'all just give us, what was the feedback from the larger committee?
So we didn't circulate this version yet, because I'd only circulated this to the subcommittee, and we hadn't discussed it yet. I did not include it in the full committee materials. So I guess the very informal sort of feedback that we received was on the first version, which folks brought up some of the similar concerns that y'all pointed out. Is this saying that the co-defendant thing, as a current client, a public defender's office can represent 2 co-defendants and all that kind of stuff, and just the concerns there, and maybe the ripple effect as well, to recognize that, some folks may want to use this for private practice. Is that kind of a slippery slope sort of thing? When I told those folks that yes, all those concerns had been raised by the subcommittee, and we had a new version that had not yet been discussed by the subcommittee that would separate out the public defender's office from the ability to screen for the current client issue. then I saw a lot of like nodding heads, I guess, and kind of relief on that regard. And so of course, we'll have to. I think everything always looks different when you see it in writing. So we'll see how everybody responds to it if this subcommittee feels like we have a working draft here.
Well, I think y'all did a great job striking that balance. I appreciate the work.
Thank you, Tara. I did see Tom Englum. You had your hand up earlier.
Yeah, from where I said, I appreciate. I was going to wanting to hear from the multi-district public defenders because the chairs they sit in are utterly different than mine, and I respect them and the chairs they sit in and the decisions they have to make in trying to find folks. So that's kind of what I was waiting to hear from. I mean, I like the balance, I like the language, and they are kind of telling me that it will hopefully benefit them going forward in dealing with these issues. So I like the working draft. I think I know we'd probably have to present it in October at the next meeting, but it might give us some good feedback when we do that.
Jay, this is Glenn at the Appellate Defender's Office. The only observation I would have is that there could be cases where a co-defendant is a former client, where for whatever reason, one person is arrested, prosecuted, their case is over, and then it takes a few years for the co-defendant to be identified, charged, and prosecuted. So in that situation, it would seem to fall under the provisions for that person being a former client. And then you would have to go through the analysis of, well, yeah, they're co-defendants, but their cases are separated in time, and the first person is a former client. That could particularly be the case with our appeals, where especially in murder cases with co-defendants who are tried separately, there could be years separating the actual convictions of people. And it's possible that one person's appeal has been completed before the second person is convicted and appeals. So, under the former client analysis, our office might be able to then represent that co-defendant, but I don't think we would do it. But the way the rule's written, it potentially could let us do that.
So and I appreciate you saying that, Glenn. One thing that I was, I guess, on those lines, because I don't want this to create the scenario where it creates appellate issues. I could, and of course, we're probably looking at this rule in the ideal situation, where somebody, like the description of, or the scenario you just described. I would like to think that a chief public defender would see that scenario and say, oh, it's a former client. I know the rule may allow us to, but we're not going to do that because it's too close in time. Everybody knew about that. We all talked about it, that kind of thing. But the rule would permit someone to do that. And if a chief public defender made that call, even if all of us on this call would say they shouldn't say yes to that, if they did say yes, then they haven't committed an ethical violation necessarily, but they've still created a problem for the case. And so I guess maybe my question is, one, I know we don't necessarily want to write the rule naively. We also don't want to write the rule for just to cut off every potential poor decision. There's got to be some independent judgment left to the lawyers. But to the extent that there's any sort of guidance, and I'm thinking about the comment down here with regards to the chief public defender making the call, do you all think it would be helpful to, I don't know how to say it, but basically to provide some attempt at guidance for that thought process? Something about, factors to consider might be, the time difference between the former client representation and the current client that's creating the conflict where this rule is coming into play. Is there, of course, the relation, like you said, a co-defendant scenario in that situation is a former client, but it's just simply too close to that case, that sort of thing. Do you all think some sort of additional guidance that we would include in comment 13 would be helpful? Or is it something that, and this is kind of the reaction, kind of the, what's the lawyer's reactions to the rules of professional conduct? If we include guidance, is that something seen as, okay, well, here's some things to look at, and I've looked at those things, and that's all I need to look at? You know, kind of the, if it's mentioned, if the bar actually included it, that's what they want you to look at, and anything beyond that, you know, regardless of their including button, not limited to language, you know, that's all I need to look at. I'm good. You know, even though we intend this to be kind of a, here's some examples of things to think about, but you really need to think about this from all different angles, even angles that we cannot contemplate or anticipate here. So it's a long-winded way of saying, do you think we need to have more guidance in comment 13 for chief public defenders? I see a shake of the head from Jacob.
I mean, we didn't get to where we are because we're morons.
Right.
I mean, I think that we all need to recognize the fact that, like, Wadrina nor I, or I think I can speak for everybody, no one would say, hey, it's okay to represent co-defendants.
Right.
Like, we can't make a rule such that every single teeny tiny thing could be in that rule. We have to have the ability to use our own common sense. So I think that we could talk this to death, but while we're talking it to death, some of us are in dire straits down here. Just that's my opinion.
I appreciate that.
I agree with what Judge Harrison Mitchell said in the chat as well. I agree that we don't need to provide further guidance. The chiefs are there. They were chosen and selected for that position. They can make that call. And we start getting in the weeds of stuff. We don't get in the weeds with anything else. And we definitely don't talk about this could raise appellate issues. I mean, I don't think there's anything that we need to be doing. If somebody has a question, that's where they call you guys, and you guys give them amazing advice. And if we need to address it, this is the one time in life that I'm saying, let's be reactive instead of proactive to getting down into the weeds of scenarios.
Great.
Tom, I see your hand.
Yeah,
too.
I agree. I agree with that. Number one. Number two, I want to go even further. Let's assume that there's a grievance based on this. And if you have the reasonableness of the bar and the counselors playing through this thing, then that's where, you know, that whole ultimate decision would take shape. And I think in my 6 years of doing this, I'm utterly convinced and comfortable in knowing that you folks at the bar will give every deference to those reasonable decisions and all the factors that go into them, to those lawyers that are on the front line and doing in the heat of the day what often we contemplate in the cool of the evening, to paraphrase some justices. So I don't like the idea of putting more language in. I think it causes more difficulty. And I think the power that we're establishing, or the decision-making authority within the public defender, is where it needs to be.
Great. Thank you, Tom. And thank you for those words about the staff. In fact, I'm going to go print those things out and post them on our website. Just like everybody know, somebody thinks we're reasonable that works at the bar.
I'll give my 2 cents. I agree. First, I mean, we've come a long way in this subcommittee from where we started with the original inquiry and circle back around. And I think, Brian, you and Nicole have done a great job of crafting this. I like it. I really appreciate all of the public defenders who are the ones, you know, on the ground fighting this. And Glenn, your input too. That's really helped us get here, I think. And I agree with the comments that have just been made, that I don't think we need to list out any of the scenarios. I think it says reasonable efforts, and you know, that'll be enough. The chief public defenders can make those decisions based on those judgment calls and all the circumstances involved at the time. So that's kind of where I am on it myself.
All of that, I just wanted to make sure people are seeing what Judge Harrison Mitchell is putting in the chat, that she doesn't want public defenders to end up getting more grounds for grievances simply because we put examples in the comments. I mean,
Yeah.
So I just wanted to make sure we're looking at that as well.
Hey, Brian, I have a comment. Oh, I'm sorry, Jay.
No, go ahead, Ellen.
Well, I like this heat of the day. I feel like I've learned so much about criminal defense practice in the heat of the day in this committee, and I appreciate y'all letting me join. I have a tiny drafting comment, Brian, based on feedback I got in Cherokee about the slippery slope with the private bar.
Mm-hmm.
Look, we know that's gonna come, like somebody's gonna ask. They're gonna ask whatever. But in the comment, if you can put the comment, or I can look at mine.
Yep.
The last sentence of the long comment. Can you?
Yep. I'm gonna put that up on.
Okay.
There we go.
And this is tiny, but where it says paragraph F and G only apply, do not permit private law firms to avoid imputed disqualification, like under Rule 1.10, right? Like keep 1.18 out, keep just make sure we're limiting it to this rule.
Okay. I see what you're saying. Yeah. Yeah, it's a bit more broad. We're specifically talking about the imputed disqualification through Rule 1.0 or 1.10. Yeah. Yep. I see what you're saying. Make sure, is everybody else good with that? I think it's just
I think that's a good point.
Yeah.
That's a good point, Ellen. Yep.
Okay. Thank you, Ellen. Eddie, did I see you unmute? Did you have some thoughts from the great state of Mecklenburg?
I did. I'm trying not to speak though, because I appreciate the work that went into this. I think it's good in some respects, and then I have other concerns. I have concerns about making chief PDs the authority here. I think it's something when we're able to go to a judge and says the state bar says this is a conflict and we can't take this case. And so by making the authority the chief PD, then it becomes that's more of a fight. And then now, the more pressure that's going to be placed on chief PDs in some places to talk about, their policy and why did you make this the policy instead of that? And I think that can create issues. I have concerns about caseloads. And again, if the policy is this from the state bar, then I think in some way that helps control the caseload. But considering it's up to each individual chief PD, and then you're going to have additional pressures in terms of why aren't y'all taking these type of cases, and why can't you do more? And again, in some areas, that's going to be very difficult. So I have concerns about. I have concerns, I still trying to figure out, our end and how we do things here versus other places. So I'm not going to say too much, but I do have concerns about making chief PDs the authority of this issue.
Thank you, Eddie. Well, I guess I've been curious, Judge Foster, as our view from the bench, Judge Ashley, when you are looking at this, and I guess I don't know, Judge Dorothy, I think you're here, but you might not be able to turn on the mic. but
I can now. I actually was trying to type. Yes, I can now. I actually was trying to type it. I'm in the midst of finishing up my lunch. I just put it in the chat, but I can say as a judge, and I've seen the significance of this on other sides because I was an assistant public defender too. Never been the chief, but I know what great job that they do have, and I trust their judgment. As a judge, I would defer to the chief PD. I would trust that the chief PD is following the state bar rule, and that, speaking specifically to what you were saying, Eddie, that you would rather it come from the state bar versus being in the discretion of the PD. It is coming from the state bar. I mean, this will be the rule, this will be the comment, this will be the guidance, using the word guidance in the overall way, that the state bar has put out. And so I would trust that the chief public defender is following all of that, and I would trust their judgment in that regard, and I would appreciate it. And as far as I'm concerned, I wouldn't see it the necessity or the need to even entertain what may be considered a fight or a question of the chief public defender. I would actually probably try to do all I could to make sure that there would not be any questioning of that chief public defender and their use of their discretion in that regard. So
I agree with.
where I am on that.
I agree with Judge Harrison Mitchell. I've been on the bench now almost 8 years. I have never, Deontay will tell you, I've never gotten in the weeds of what are you doing and why is it not having this, that, and the third. And I wouldn't, because at the end of the day, you know, if they tell me there's a conflict, they need to come out, then I'll let them come out. You know, we honor that as we should. So I don't know. I mean, I speak for all 300 some district court judges and 200 some superior court judges, but I don't see that as our place to get in the weeds to tell you, you shall represent this person and that person. I mean, I think once again, empowering all 100 counties to do what they need to do, I think is most important, and not just limiting ourselves to our own individual insights.
Well, I know you all wouldn't, and that's what makes you great judges. I know I've had experiences where things went a little bit different. I know other people in my office have had experiences, and not just my office, in other areas, of the state. But I'm not saying that's what we should base our policy on. I just know that that's something that I take into consideration when I think about how I feel about this topic.
Yeah, just to speak again on our behalf of our association, I think one of our former meetings, there's disagreement amongst the board or amongst the chiefs about, the best way to tackle this, but especially hearing from Jacob and his situation and Wadrina, I think their opinions have to roll the day, and we're always going to have to deal with different levels of judge interference, and it's up to us to establish those relationships and put our foot down when needed. So I appreciate it, us being where the buck stops, and I think we'll just have to deal with that on a case-by-case basis. I just don't want us to dictate something statewide, especially when I'm coming from Wake and I have a good amount of resources and, knocking on wood, a good amount of private sound counsel as well when, we have my colleagues dealing with a whole different situation.
Can I
So
jump
do we
in?
need to make a motion for this?
So can I jump in real quick? So I just want to say that hearing that, Eddie, as well as what you stated, Deontay, I think this lends itself to us taking advantage of the opportunity to educate our judges. Maybe see if we can have someone, and even one of us, Judge Parker or somebody from the state bar, go and speak with all of our judges so that they could be reminded and be mindful of what issues we have. I know we've referred to it as legal deserts, and then we've heard it called legal oasis, right? So we want to try to change that wording and that outlook. But I think this lends itself to an education opportunity and encouragement opportunity for our judges to realize and recognize that the state bar, if we go with this rule and it goes through this process as we would like for it to go through, then it will be the rule. It'll be included in the rule. There is some guidance there where the judges are reminded, like, yes, the chief public defenders have this authority and that discretion per this state bar rule and these comments. And that we just remind the judges that, hey, there are places, and I know some of you may be in some of these places in which this is happening, or you may see it as a great need, but you need to trust your public defenders. You need to trust your chief PDs, and that they are going to make the right decisions and help and encourage them, because if they are put in a position, if the judges, I see it as if the judges encourage or getting involved in those weeds, using Judge Parker's word, getting involved in those weeds, then that could lessen the approach or the ability of the chief public defender to get more people on their list altogether. And so I feel like it could lead to more negative things that we really don't want. So I hope that we can use this, like I said, as an opportunity to educate and encourage our judges across the board to support our chief public defenders more, as opposed to causing more friction in a way that we don't need it to be caused.
I agree.
All right. Is there any further comment? I want to make sure everybody gets a chance to speak, but if not, I think we're in a position we could probably ask for a motion and we can vote to send it to the full committee and go forward. That's the pleasure of the subcommittee. Anybody else have any comment? All right. Anybody have a motion?
I move that we accept the recommendations from the staff as to the rule and the opinions. Excuse me, rule, opinions, and comments.
Thank you, Judge Parker. Is there a second?
I second that. I just wanted to make sure we're talking about that one edit that was pointed out earlier in the meeting.
Yes, including that edit. Yes.
And that's I want to clarify that is on your screen right now. And Ellen, would this highlighted language accomplish what you're talking about? Okay.
Brian's quick with the typewriter, man. He's already got it done.
I got it.
Thank you.
I second that motion.
All right. Well, we have a motion and a second. Is there any further comment? Any discussion? All right. Well, let's see a show of hands so we can make sure. Anybody, all in favor, please raise your hand that we can see. All right. Any opposed? Then please raise your hand. All right. Well, that motion passes then. We will send it to the full committee in October. And again, I thank you all for your participation, your comments, your hard work. We've met several times. So it's good. It's been great working with you to get this done. I think this is a good step in the right direction. So I appreciate it. And
all right. Well,
Ryan,
we'll
Nicole,
put
anything else we need to do, or can we?
Yeah, no, I was going to say, so we'll put it on the full committee agenda for October. It's going to be, I guess the recommendation from the subcommittee would, be to kind of take that next step. Next step would be publication. And I think, presuming the ethics committee goes and publishes, of course, it's going to go through the full council since it's a rule amendment. So we'll have to go through all that. But when we get to that point, if it does get approved for publication, we will let everybody on this call know, particularly those that are outside of the council, whether you're a council member or an advisory member, so you can let folks know, this, hey, keep an eye out in the journal. I know everybody is just dying for that copy of the journal to hit their mailbox. It's coming soon. But this next issue will be particularly fun because you all can point out this rule and say if anybody has a comment or thoughts or anything like that, any suggestions, something that we missed. We want to hear it all because we want to make sure that we get this right. So we'll let everybody know and get the word out and see where it goes. I really appreciate everybody's thoughtful participation here. This is a great example of how the ethics committee works and this idea of self-regulation when we all pull together and actually come up with a good new step in the profession. Second
that, absolutely. And Nicole and Brian, thank you again for all your hard work and on all these different drafts. All right. Well, I think we're done for today. So thank you all for joining, and we'll see you in October.
That sounds great. Thanks,
all right.
y'all.
Take care, everyone.
Take care.
Bye-bye.
Bye.